Let us learn today all about criminal attempts. Here we shall discuss the approach of IPC pertaining to attempt, what are the meaning and essentials of attempt under section 511 IPC, and also impossible attempts. What is an attempt? Attempt is the direct movement towards the commission of an offense. So, the act which a person does towards committing the offense which he is intending to, but which gets hindered by circumstances out of his control. So, those acts are termed as attempts. So, attempts are intended actions but which did not result in the ultimate crime commissions for reasons whatsoever. Now let us check what is the criminal liability of attempts, which means could all attempted crimes be punishable in law? Here let us take a quick revision of the criminal liability of various stages of crime commissions. We have discussed it in our previous lecture. This is just a glimpse of the entire stages with its culpability. Starting with contemplation or intention, which involves a thought of a person in committing the crime. This is not punishable in law because this is just the thought process involved and it is not triable also, this stage. Okay. Now moving on to the second stage, which is preparation. Preparation means it is arranging or devising measures for the commission of the offense. What all things are procured, collected, etc. for the crime commission is preparation. This stage is also generally not punishable. But there are certain exceptions which consist of preparations to commit heinous crimes like counterfeiting coins, waging war against the government, etc. But the general rule is that it is not punishable. Now moving on to the third stage of crime commission, which is the attempt. Attempt is the direct movement towards the commission of the offense. This is the stage which is punishable in law. Okay. Other than commission, this is the stage which is punishable. Why is it punished? Because law would wish to nip in the bud the crime. If law steps in and punish the wrongdoers at this stage, probably the crime commission will not happen. And that is why law would wish to nip in the bud the intended crime. And fourthly, the commission stage, which is always punishable because we are talking about the substantive offense under consideration. I hope it is clear to you. So, we are discussing in this lecture the third stage of crime commission in detail, which is attempt. We have already discussed what inchoate crimes are and what are the three different categories of inchoate crimes, wherein attempt is the first category of inchoate crimes. Now let us analyze how attempt would be an inchoate crime. Let us check the liability of A in this particular example. A shoots at B to kill him but misses the aim. Here suggests that A had shot B but missed the aim, which means that he had done certain acts but it got hindered due to some external circumstances, isn't it? But that particular act of shooting B but missing the aim is relative to the offense in chief, which means the crime committed by A would necessarily fall under the head of inchoate crimes. Crimes which have begun but did not end up in the intended crime. Got it? Now let us see how IPC has dealt with criminal attempt. IPC has dealt attempt in three different ways. In the first class of attempts, attempt and offense are dealt with in the same provision, which necessarily means punishments for both are also provided in the same provision. Provisions dealing with offences against state, offences against public tranquility, offences relating extortion, robbery, dacoity, etc. are some of the offences wherein attempts are also mentioned within. In the second set, you have attempt to commit offences dealt separately within the code, and hence separate punishments are also provided within those sections. Attempt to commit murder, attempt to commit culpable homicide, attempt to commit robbery are few examples to this section of attempts. Attempts that are not covered in the above two classes are the third category attempts. Section 511 of the IPC deal with such category attempts. Attempt is not defined in the IPC, but let us find out the meaning and essentials of attempt from the available resources. When there is an intention to commit an offense and the doer has committed some act towards the commission of the offense which has exceeded the stage of preparation, but for some reason has failed to commit the expected or intended offense, then it becomes attempt. In short, intention plus some overt act towards commission plus some reason of hindrance for committing the intended offense is attempt. If so, what is the punishment provided for such an attempted offense? We have already seen the punishments provided for the first and the second category attempts. Now let us see what is the punishment provided under section 511 of the IPC, which are attempts not covered under the above two classes of attempts. The punishments provided in the provision are imprisonment of any description provided for the offense, the actual intended offense, or one half of the imprisonment for life, or one half of the longest term of imprisonment provided for the offense, or fine, or both. Now let us analyze this problem. A attempts to pick the pocket of B by thrusting his hand into B's pocket. A but finds nothing in it. Could he be held liable for attempt to commit theft? The moot question here is, can there be an attempt to commit an act which is impossible? Law labels such cases as attempts to do an impossible act, or shortly, impossible attempts. There had been many contradictory decisions pertaining to impossible attempts as early as 1800s. As a matter of fact, Section 511 of the IPC, through its illustrations, has clearly stated its culpability. Let us quickly go through illustrations A and B to Section 511 IPC here. A makes an attempt to steal some jewels by breaking open a box and finds after so opening the box that there is no jewel in it. Here, the illustration specifically mentions that he has done an act towards the commission of the theft and hence he is guilty under this section. This is for sure a case of impossible attempt and the illustration specifies that the doer is guilty under section 511. Alright. Now on to illustration B, which is similar to the example put to you. A makes an attempt to pick the pocket of Z by thrusting his hand into Z's pocket. A fails in the attempt in consequence of Z's having nothing in his pocket. Illustration to section 511 says A is guilty under this section. Thus, impossible attempts are also covered under section 511 IPC and are also punishable. Another example here, A and B inflicted both serious and minor injuries on each other. Could they be charged for attempt to murder or just attempt to cause hurt? Here the answer depends on the intention of the perpetrators. What was the intention present in the minds of A and B while causing injuries on each other? It could be deduced from the circumstances, right? These are all questions of fact. Now, how do we ascertain what is the intention from the circumstances? You have to look into the nature of the weapons used. the manner in which it was used, the severity of the blow, the part body which was injured. If from these it is clear that the intention was not to cause just hurt, but it was to cause murder, then of course they could be charged for attempt to murder, or else attempt to commit any other less serious offenses. Got it? And here this week's problem to ponder. A and B fired a chowkidar who attempted to arrest them. A pulled the trigger, the cap exploded, but the charge did not go off. Could they be charged for attempt to commit murder? Please post your answers in the comment box along with your feedback and suggestions. Till we meet next. Bye bye.